Good afternoon. Good afternoon. Thank you for coming out on this rainy, foggy day. I'm sure you won't be sorry that you did, but I'm going to turn this mic over now to Hal Bailey, Provost. Emeritus? Okay. To make the introduction.
Great. Hey, thank you, Sandra. As many of you know, my favorite quote from Benjamin Franklin is his response to a woman who asked what kind of government the Founding Fathers were presenting us. And he said, "A republic, if you can keep it." And his words were prophetic, because if democracy is anything, it's a conversation and a bit of a struggle. And currently we are facing, obviously, a rather remarkable constitutional challenge. A challenge that has been defined advertently and inadvertently on both sides by its appeal to partisanship. And as a recent book on the death of democracy suggests, it's precisely that partisanship and the increasing radicalization of that partisanship that provides one of the biggest threats to democracy. So it's, from my perspective, it's troubling to see what is going on with the impeachment proceedings as we become more and more partisan about it. In light of that, it was prescient and wonderful that we have today's speaker, who is, on the one hand, one of the most insightful constitutional and legal scholars I'm aware of, and secondly, is about as thoroughly nonpartisan and rational as you could ask anyone to be. So I think we're very fortunate to have today's speaker speaking, of all things, on the premier constitutional challenge facing us today. And so it's my honor and privilege to invite to the podium one half of the premier cultural the cultural couple in Scranton to straighten things out for us, give us the nonpartisan thread that makes it all clear, our own sort of Alexander the Great as he cuts the Gordian knot. And yes, he'll criticize me for going a little overboard on this, but here's Morey Myers to talk about impeachment.
Thank you, Hal. Having sufficiently insulted me in terms of description of nonpartisan, now you understand why you're no longer the provost. First, I want to recognize some women. One, the director of the program, who is almost unfalteringly brings leading academicians, public officials, public intellectuals, artists. She almost never falters, except when she insinuates nepotism into the picture. So to Sandra, thank you. As she's been described, she brings the world to Scranton. And a couple of other ladies who are the reverse of impeachment. They're going into office. One is Janet Brier. I don't know if Janet's here. She was scheduled to be here, but Janet did the impossible. She conducted a write-in campaign in Dunmore. Now, all the analysts say one thing you can do is recognize that in Dunmore nobody knows how to write. But that's the analysts. The analysts were proved wrong And Janet, if my fourth grade arithmetic is correct, tomorrow she's going to be officially recognized as a borough councilman in Dunmore in a very challenging assignment. Hey, Todd. Oh, there's Todd Bailey here. Todd, national championship of 1983, Todd? Yeah, whoa, amazing. And then went on to a very illustrious basketball career with the Washington Generals. They had the distinction of playing with the Harlem Globetrotters for maybe thousands of times and never won one of the games, did they, Todd? Yeah. The other woman I want to recognize, she became a citizen less than a year ago. And lo and behold, she's now an elected school director in the city of Scranton, Ro Hume, who's about to take office in 3 weeks. Good luck to both of those ladies in their very grueling but important roles. So, impeachment. First, what is impeachment? Most of us exaggerate the notion of impeachment. In description, impeachment is merely a charge. It's been described as the indictment, the bringing a charge against a public official, and then the process requires the deliberation of another body to make a determination and disposition of that offense. However, popular usage encompasses both of it, so impeachment now really includes, at least in our ordinary reference to it, both the charge and the process of determining the guilt of the public official. The term comes from French and Latin. You scholars of either of those languages may be more precise about it, but it means something like entanglement. So here I am, I'm about to talk to you about impeachment, and I guess that many of the people know at least as much as I do about it, and we're probably somewhat fatigued about the subject. So that's the dilemma. Let me try it this way. Let me talk to you about the origins of impeachment, how, why, and what we did in this country in terms of our constitutional provisions, what were the 2.5 presidential impeachments, and I'll explain what I mean by the half, and of course the current situation. We go back to 1386. A man by the name of L.L.B. He was a chancellor to Richard II, the young King of England. And at that time, the king could do no wrong, nor could his family. The king could shoot anyone on Fifth Avenue and have no responsibility. So the subjects said, we have to do something about this. If we can't eliminate the king, let's at least try and sometimes remove those who surround him and help him making his decisions. And so L.L.B. was charged with, among other things, buying land from the king at a distress sale and then selling it at a large sale. And in that charge, they put in the term of high crimes and misdemeanors. Didn't mean anything at the time. Still doesn't, in my opinion. Misdemeanors was not a crime, but the term was introduced. He was found guilty and sentenced, did serve some time. Now, from that point, England rolled in and out of impeachment. For 75 years, they adhered to it, then they had a lapse, and then they ultimately eliminated it. But before they eliminated it, in 1786, and remember that date, I'll indicate in a moment why that's relevant, they tried to impeach Warren Hastings, the Governor General of India. And why the last impeachment in England was in 1806. Why? Because the power moved from the king to the parliament, and the parliament then had the process of eliminating public officials if it wanted to, with votes of no confidence and those kinds of things, so it became irrelevant. However, our country, remember I said Hastings was charged in 1786. His impeachment proceeding went on for 9 years. During that time, in 1787, our Constitution was convened at a convention to correct and undo the Articles of Confederation. The Articles of Confederation were faulty in that they had no central executive, they had no central courts, they had no capacity to tax. It was really a league of states gathered together. It did have some virtues, but by and large, it was considered a pretty impotent constitution. However, it was our first constitution. And so they gathered in 1787 to write a new constitution. Now, they were very much concerned about an executive who would have great powers, since they fought a war just a decade before that, in which they challenged King George III basically on his excessive mistreatment of the then colonies. So they were quite conscious of not giving extensive power to the executive. And yet, on the other hand, everyone knew who was going to be the president. There were only two prospects of national figures. One was George Washington, and the other was Benjamin Franklin. But Benjamin Franklin was old and sick, and he wasn't an applicant. So it knew it was going to be Washington. And there were some proposals at the time to have a committee of executives, 3, like our county commissioners. But I won't comment on that. But on the other hand, they said, no, we can't do that. We have to have focused accountability on a given person. And furthermore, we can't insult George Washington. So, they said, what about removing him? Well, Benjamin Franklin said, there are only 2 ways to remove the president. One is to impeach him, and the other is to assassinate him. And he said assassination doesn't give the victim the opportunity to vindicate himself. So let's go with impeachment. Originally, now remember, the Constitutional Convention lasted for less than 4 months, and a new Constitution came out in that period. So the original proposal was treason and bribery. And then they had not too much discussion about impeachment. But in the last week of the deliberations, right before they're going to send the Constitution to the states for consideration and hopefully ratification, George Mason, a pretty unheralded person in American life and an important public founder, said, wait a minute, treason and bribery, that's too limited. It should be treason, bribery, and maladministration. And James Madison said, well, wait a minute, maladministration, that's the guy who just goose up in the administration. That leaves it to the whim of the Senate, and the president is serving at his pleasure. And Mason said, all right, Jim, you're right. It's going to be treason, bribery, and high crimes and misdemeanors. Now, it was as meaningless then as it was in 1386, 400 years before, when the first term came into being. It was a term of art. It certainly didn't intend to have misdemeanors, such as going through a stop sign or exceeding the alcohol limit or disorderly conduct, the basis for impeachment. But nevertheless, the term came into being. So it was enacted. Now, I've put before you a sheet here to indicate what are the constitutional provisions that we're now going to be hearing about in the course of the latest inquiry. There are 6 provisions in the Constitution, and that's a lot, and yet doesn't say too much. So let's start with the first one. It says, the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. All right, so who can be removed? The President, we know what that means. The Vice President, we know what that means. Civil officers, what is that? Well, the first impeachment proceeding that came shortly after the Constitution was adopted and the new form of government came into being was in impeaching a man by the name of William Blount, who was a United States Senator. He was impeached, went to the Senate, and the Senate, whoa, hold it. We're not civil officers. We're elected by the states. We are representatives of that. It doesn't have any application to us at all. We have our own process of considering and removing inappropriate officials in our body, but impeachment does not apply to members of Congress, notwithstanding that our current president has said, I think we ought to impeach Mitt Romney. He's in total error. There's no prospect of it. It's not permitted. There we see the term embedded in there of treason, bribery, or other high crimes and misdemeanors. The second provision, the House of Representatives shall have the sole power of impeachment. When it says sole power, it means sole power. No one else can bring a proceeding except the House of Representatives. It can't the United States Senate, it can't any courts, it can't any individual. It is exclusively within the House. And so we go on. What happens? Article 1, Section 3, the Senate shall have the sole power to try all impeachments. Again, it's the Senate, nobody else. No courts. If the Senate makes a determination, that is it. That's final. There's no review of that by the Senate. It has the sole power. And when sitting for purpose, they shall be on oath or affirmation. Even though they take an oath when they go into office, the Constitutional Convention said you got to take another one for this purpose. Now, when the President of the United States is tried, the Chief Justice shall preside. Why? Well, they said it's so monumental that we want the importance of it to be have the Chief Justice come. And furthermore, they said, who is the presiding officer of the Senate under ordinary circumstances? It's the Vice President by the Constitution. We don't want the Vice President sitting there in judgment of the President, licking his chops and saying, hey, ooh, we can get rid of this guy, I'm there. Now, so you ask the next question. Who presides when the Vice President is impeached? There are legal purists who will tell you the Vice President presides when he is under impeachment. Now, there's also a rule of law called the Absurdity Rule that says, how can the Vice President be presiding over his own impeachment? Well, it's not as remote as you think. Some of you may recall Spiro Agnew. All right, Spiro Agnew asked the Carl Albert, Speaker of the House of Representatives, to impeach him. Why? He was aware that there was an indictment that was probably going to come down, and he thought he could get a much more favorable treatment in an impeachment process than the other. And I submit he also thought, maybe I'll be presiding over my own impeachment proceeding. So that isn't too long ago that we did face that. Needless to say, Carl Albert rejected that. Agnew was charged, resigned, and was punished appropriately. When the president, and no person shall be convicted without the concurrence of 2/3 of the members present. And that's a very substantial challenge. That is one that means that you really have to get both parties in agreement, and this situation has to be so egregious and so non-political in what is a purely political process that you will accomplish something. Now, what happens if he's impeached and convicted? The next paragraph, judgment in case of impeachment shall not extend further than to removal from office. It is suggested that when it says not further than removal from office, it could actually be something less than removal from office, although that is unclear, because the first paragraph says that upon conviction he shall be removed. So the question is, can the Senate say, well, we'll only censure you? Or can the Senate say, we'll only tell you don't do it again? There is strong indication that the Senate could do something less than removing him. And shall extend further than removal from office and disqualification to hold and enjoy any office. Now, this is a little tricky. It's a double-barrel thing. You're removed and you can be disqualified from further office. What has actually happened? And by the way, it's 2/3 vote for removing you from office. The rulings of the Senate has been it's only a majority that you can't hold office again. That's unclear as to whether that is constitutionally correct, but nevertheless, that's the practice of the Senate, and that's the way it's been operating. 19 impeachments. 19. 2 presidents. 15 public officials, all federal judges. 2 cabinet officers. 19 impeachments. 8 convictions. 7 acquittals. 3 resigned before, and 1 was William Blunt, who was in the Senate, and the Senate said, we have there's no jurisdiction for us to impeach. We can remove him, but we can't impeach him. 19. So 8 convictions. Of the 8 convictions, only 3 said you're disqualified for office. So it is conceivable that Donald Trump could be convicted, not disqualified from office, and run again. That actually, what has happened in a given situation, a federal judge by the name of L.C. Hastings was tried in Florida for a bribery and some other crimes, acquitted. He was then impeached by the House, convicted by the Senate, thrown out, but they didn't disqualify him from further public office, and so L.C. Hastings is now in the Congress of the United States, the very body that threw him out. Okay, so further on this, a disqualification, a party convicted shall be liable and subject to indictment, trial, jointment, and punishment according to law. In other words, what they are saying is that the impeachment and the conviction is not a criminal proceeding. It is merely removing from office somewhat. It doesn't prohibit an actual trial to take place. So you don't face the issues of double jeopardy and those kinds of concerns that were there before. It's not viewed as a punishment. It is really deemed an alleviation of an inappropriate situation and asking that the public official be removal. It's almost like a corporate office the board of directors throwing out the executive officer with the limitation of that. Understand again, it is not criminal in nature. The debate goes on, is it criminal? It's clear to me it's not. And finally, a couple of secondary provisions, that the president shall have power to grant reprieves and pardons for offenses except against the United States, except in cases of impeachment. And the concern was that the president could really be a co-conspirator in a process and then grant a pardon. And they say you can't do it with impeachment. Okay. Those are the provisions. Now, how did they apply? Well, George Washington was considered for impeachment. Thomas Jefferson was considered for impeachment. Now, none of those moved beyond just suggested challenges. Nothing happened until John Tyler, the 10th President of the United States, who regularly challenged Congress in every action, was brought to an impeachment vote, and in the House it was voted down. So we come to our first impeachment. Andrew Johnson. Who was Andrew Johnson? He was the 17th President of the United States. He succeeded Abraham Lincoln. As he went to school, no official school, self-taught. And when he got married at the age of 17 or 18, his wife taught him how to write. Before that, he didn't know. But he was a very effective orator, and he became a significant public figure in Tennessee, elected to Congress 5 times, governor of Congress, then in the United States Senate. And he was the only senator in the South that did not leave when the Civil War commenced. He was a racist. However, he did free his slaves. And in 1864, Abraham Lincoln and most of the country said, Lincoln is not going to be reelected. Lincoln thought that, but he said, I have to do something. He had a very effective vice president, Hannibal Hamlin, who was a strong anti-segregation official, and he dumped him. And he selected as his running mate Johnson. Changed the political party, didn't run as a Republican because Johnson was a Democrat. Changed the parties. Lincoln is reelected. A month into his service, he's assassinated, and now the unthinkable, Andrew Johnson is President of the United States. From the beginning, they tried to challenge him, particularly two guys, Thaddeus Stevens, a congressman from down Lancaster, and Charles Sumner, a U.S. senator up in Massachusetts. And they said, we think we know how to get this guy. We're going to enact the Tenure of Office Act, in which any removal of an officer, of a cabinet member, has to receive confirmation from the U.S. Senate. No provision in the Constitution for that, deemed to be unconstitutional. Johnson did not pay any attention to it, and he did discharge the Secretary of War. So he's indicted, he's impeached, goes to the U.S. Senate, and of the 54 members of the Senate, 42 are Republicans. So Sumner thought he had it in the bag. He was going to get rid of this guy. However, the successor, the Speaker of the House, was someone that people didn't want, and so it became an issue. Johnson was saved by one vote, but it was believed that there were many in the wings that if Johnson didn't have that one vote, there were others who were going to get it. They weren't going to have this impeachment on what was considered an inappropriate basis for him. Next, Richard Nixon. In June of 1972, a break-in into the Watergate. Whether Nixon knew and was involved in that break-in is unclear. But 6 days later, when he's meeting with his chief of staff, H.R. what's his name? Haldeman. Meeting with Haldeman, and he's told all about it, and he says, "Okay, we got to cover this thing up," and he starts on a cover-up. In November, his election, he wins in a landslide, losing only one state. But it starts unraveling about this. October of the next year is the massacre, where he wants the investigation into the irregularity of Watergate stopped. And he tells his Attorney General, Elliot Richardson, stop it. Richardson says, I won't. Okay, you're fired. He goes to Richardson's Deputy Attorney General, William Ruckelhaus, stop it. He says, I won't. Okay, you're fired. Then goes to Robert Bork. Bork says, okay, I'll do it. So they're fired, and it begins to unravel. The following year, in early '74, Haldeman, John Mitchell, the Attorney General, and Ehrlichman are indicted, and it becomes clear that Nixon had a hand in the whole proceeding. So comes to July or early August of 1974. By the way, Nixon having won by the largest majority of any president in American history is now about to be indicted. 3 people go to the White House, 3 Republicans. Hugh Scott, the minority leader, senator from Pennsylvania. John Rhodes, the minority leader of the House from Arizona. And Barry Goldwater, a very respected conservative. And they say to Nixon, it's up. You're out. And Goldwater apparently says to him, there are only 4 or 6 U.S. senators that will support you, and I'm not one of them. The next day, Nixon resigned. Now that's the half I call, because clearly he would have been indicted by the House and very likely convicted by the Senate. Number 3, Bill Clinton. Bill Clinton, we know of his irregularities and his misconduct in a personal way. We know of his carryings on in the White House. But it was believed by most that the Clinton conduct did not affect the public welfare. It was his private abuse that was. So it became a little suspect. And his carrying on with the intern, Monica Lewinsky, it was viewed as personal in nature. And so Trent Lott, the majority leader of the Senate, and Tom Daschle, the minority leader, said, look, they both agreed this one is going nowhere. He's not going to be convicted in the Senate. The House didn't bring charges against him. They impeached him. Let's limit it in a way, and it was a very civil, orderly proceeding where they agreed that before the senators would get on with their song and dance and carry on about the irregularities of Clinton, let's get all the information out and let him be aware that it's not going to happen. He's not going to be convicted. It was an orderly process by two responsible leaders. They ran through the proceedings, and the feeling with the public was that Clinton was a terrible husband, but a good public official. And he had high ratings, and his ratings went up after the proceeding. So we come to the current situation. In the current situation, I have some hesitancies about the haste in which the Democrats are bringing this and limiting it to conduct with Ukraine. It is clear to me that Trump directly and through surrogates said the $391 million of assistance that we're going to give you is dependent upon you bringing an investigation against a leading candidate of the Democrats and his son, Joe Biden, and you publicly declare that. At first, the challenge to that was, well, there's no quid pro quo. Well, I think it's now been confirmed by several officials. William Taylor, the representative, the ambassador to Ukraine, others have all indicated, oh yes, there was. It was that the request was such that it had to be something that was irresponsible. So now the challenge to that is, well, we're now agreeing that yes, there may have been a quid pro quo, but it isn't impeachable. Well, what is impeachable? Gerald Ford, in 1970, as a minority leader, said an impeachable offense is one that the House of Representatives considers impeachable at that moment in history. And he has been seriously maligned for that, but I think he's pretty accurate. That's what it's turned out to be, and that's what it is. So that where is, if I were doing this, I would not limit it to the Ukraine. I would say, hey, wait a minute. You've got Don McGahn, who was the counsel to the president, and who incidentally has local connections here. He's Julia Munley's brother-in-law. When Trump called him and said, I want you to call the Department of Justice and get Mueller fired, he said, I refuse. And if you want, I'll resign. Trump said, okay. He then went to Corey Lewandowski, and said, you get Sessions, the recused Attorney General, to tell them, the Department of Justice, to limit the prosecution to future events and nothing in the past. Lewandowski was a little more obedient, but he never accomplished that. Back went Trump to Don McGahn months later, when it was developed that, hey, he's made this contact with McGahn. McGahn refused, and he said, McGahn, put a memo in the file that I never had any conversation with you. McGahn said, I refuse, and I'll resign. With Manafort, Trump has said, attaway, don't let him flip you. He's actually actively participated in encouraging Manafort with the suggestion that he would give him a pardon at some point. It hasn't happened, but who knows? So there we are. Hal, you've seen my nonpartisanship has just been dissipated substantially in my sense of the appropriateness. I think that impeachment of Donald Trump is at least the equivalent of what was the impeachment, intended impeachment of Richard Nixon. And in the Richard Nixon vote in the House, the vote to proceed to the inquiry was 410 to do it, 4 opposed. With Trump, it was 232 to do it, all Democrats, 196 opposed, all Republicans. So I see on the board there it says impeachment. Is it still available? I think how it's available is only this way. You have to have both houses of the Congress of one political party and the president of an opposite political party to really get to a meaningful prospect of impeachment. So I think that if you're asking me what's going to happen, I think he probably will be what we call impeach the charge, and the Senate will promptly vote for an acquittal. So thank you, and let's hear about some questions. Michael.
Thank you very much, Morey. This has been great for a chemist. I've learned so much. But I think I may have misunderstood something. It takes 2/3 a vote of the Senate to convict.
Yes.
But did I understand you to say that it only takes a majority who can decide for disqualification
Yes.
for running for office? So it could mean that they could do that with a majority in the Senate and he couldn't run for a second term?
What I said is this, Michael. It takes 2/3 to convict. However, that is by provision of the Constitution. The Constitution is silent other than saying disqualification for office. In the disqualification for office, 3 instances in which there has been a disqualification, all of them only required a majority vote. So it's a little bit ironic that you need 2/3 to convict and only a majority to disqualify. But if there's a reluctance to disqualify, since, as I said, of the 8 convictions, 5 they did not disqualify. Elsie Hastings sits in the very same body that threw him out because it didn't impose a disqualification. It is possible that if the president was to be convicted on a 2/3, that they still would take no action to disqualify him, and he could run. If they disqualified him, he couldn't run.
But it still takes 2/3 to do that.
To convict, only a majority to disqualify. That is somewhat challenged by those, but nevertheless, the Senate has 3 instances, there have been 3 times in which they're disqualified, and it's prevailed. And as I said, nobody can challenge what the Senate decides to do. It's the final authority. There's no review to the courts on impeachment. It is final, yes or no. Now, so it is possible they could say, Mr. Trump, you're removed from office, say nothing more, and he could run again. Yeah.
Bill.
You mentioned the Ukraine situation and also the situation with the special prosecutor and attempts to fire the special prosecutor. Do you see any other conduct that you think falls within the ambit of high crimes and misdemeanors?
Do I see any other
instances of conduct besides those 2 categories?
Oh, sure. I see when he said to Manafort, hey, great for your not flipping. He's subtly perhaps considering giving him a pardon. And now Comey, he's in his office with other officials, Mike Pence and others, says, get out of here, all you, only Comey. says to Comey, hey, can you see your way clear? This is related to Michael Flynn, to let this thing go, to give him go clear. Is that him? And then he fires Comey and says, I fired Comey because of the Russian investigation. Now, to me, that's rather startling. Yeah, so those are at least some others. I mean, there are many others, but I think that the House, I think it's short-sighted in saying, hey, let's make this clear and simple and just Ukraine. Because now it's appear what the opposition to impeachment is saying is, okay, there was quid pro quo. William Taylor, the emissary to the Ukraine, is clearly saying that. The ambassador who was removed is clearly saying it. Morrison and a couple of others are clearly saying it. They have at least 5 people saying it's quid pro quo, but they're saying, so what? It's not impeachable. It's not an impeachable offense.
Morey, that actually is what concerns me more than anything else. If you elect a person who has no concept of the Constitution or anything else, you can't be surprised if they behave in a way that you would not expect them to do it. What concerns me is that if the Senate acquits him on using his presidential powers against a domestic political rival, they are condoning and making acceptable the imperial presidency. Because what president in the future is not going to take that as a blank check to use the IRS, the Justice Department, the all of the institutions of office in this way, as it's been proved it's not an impeachable offence?
Yeah. Well, Ro, and again, thank you for your commitment to public service. Good luck. In 3 weeks, she's going on to the school board, and well, what an assignment. But I originally was opposed to impeachment, very simply in a political sense. And when they talk about is impeachment political or legal, it's not legal at all. It's clearly a political process shrouded in a legal kind of approach. But I think the House had, with all the conduct that, in my opinion, has come out, has no choice but to proceed, fully aware that the prospects of 2/3 of the Senate convicting him are very remote. And I mean, when Lindsey Graham is sitting there and saying, "I'm not going to read anything. This is nothing that it indicates the difference between a criminal trial and a civil trial, and an impeachment. In a criminal trial, courts are very cautious about making certain that the jurors, the bodies who are deliberating the outcome of the result of the charge, have no familiarity with the case, no predisposition. Here you've got the Republican senators will clearly be in contact with the White House on approach, and the Democratic senators will clearly be in contact with the House of Representatives, the prosecutors who are bringing this charge. So you don't have that kind of purity of purpose that a trial has. And Graham has said, as one example, I don't care what it's, I'm not going to read it. I don't have to read it. There's nothing. He said, so what? It's a phone call, is how he described it. Well, it's way beyond a phone call. And it's interesting that the whistleblower has now gone to the background, and 5 people have come forward and said there's a quid pro quo. So it's moved from challenging the secondary hearsay to a no quid pro quo to quid pro quo, but no impeachable offense. But it's rank political, and that would be no matter what. Now, should it be that way? Perhaps yes. I mean, we shouldn't have the whim of members of Congress, who I say whim, but they're generally responsive to their constituents. But it shouldn't be that a group of 67 senators decide whether a president is moved when 135 million people have voted for a president. So there's that concern that let's make it as burdensome as possible, but let's make it available. And so when I say, is it still available, I say, it's not so available. Yeah.
About 2 years ago, I think it was Congressman Al Green of Texas said that he favored impeachment to punish the president. And I don't really think the underlying motive has changed that much since then. I think the real motive is to put a scarlet A, or scarlet I in this case, on Trump's forehead so that next year, 7 words, only the 4th president to be impeached, will be on every placard, every bumper sticker, and every ad on television. I think that is really the bottom line of what's going on here. Not to remove him. I don't think the Democrats ever intended that. It's simply to stain him irredeemably.
Yeah, well, I would agree with you in part and disagree in part. I would say that purpose of it is removal, is not punishment. And that's why there's a constitutional provision that says you can proceed with a trial and an indictment and charge, criminal in nature, and there's no double jeopardy. So that this is only to remedy a situation that says the president is inappropriate in the job and dealing largely with corruption. And that was the basis on which the founders said there should be impeachment. Now, you say about the motivation, I think Nancy Pelosi was clearly opposed to impeachment. She didn't want it at all. She said it's going to occupy the energies of the Congress. It's going to call the Chief Justice of the United States to be removed from his duties and preside over. She didn't want it and was able to forestall impeachment considerations until it became so clear that there was an appropriate, in my opinion, an appropriate basis for the impeachment, and therefore I disagree with you. On the other hand, Bill Clinton was impeached and tried, only the second president in our history. His polling shot up after the result was in. Therefore, if Donald Trump comports himself in a way that is responsive to what the American people consider presidential, he may very well benefit from the process if he gets an acquittal. Yeah. All right. It looks like they're coming to you. Uh-oh, I got a distinguished lawyer about to.
Could or should violation of the emoluments clause in the Constitution be the basis for an impeachment charge?
Absolutely.
Particularly in view of the fact that there doesn't seem to be another remedy for such a violation.
Yeah, absolutely, Ty. It should be, but it's much more obscure. How many people know how to spell emoluments, and how many people know what it is? So to get the, yes, it should be. I mean, is he a beneficiary when he's promoting his Doral Mar-a-Lago place in Florida? Sure, that's misconduct that could rise to impeachment. But I think they're saying that's a little too obscure. Emoluments itself is not, but yes, it is a basis and could be considered, yes.
Over here.
My wife, she's about to tell me we're going out for dinner tonight. Or she's going out alone. She doesn't like what I say.
Is impeachment obsolete? Is it a useful tool rather than the law, using criminality?
Thank you, Gouverneur Morris, of one of the founding fathers, who said impeachment, although he later succumbed and said, okay, it's okay. He said, oh, wait, there's a process. And the process is an election. And let the people decide, rather than putting this to this political body called the Congress, which may or may not be responsive to current national attitudes. I don't think it's obsolete. I think there is some conduct that is so inappropriate, so reprehensible, that it should be reviewed. But is it available when I ask up there? Not really. You have to have, the formula is very simple as I see it. You have to have both houses of Congress of one political party and the president of another political party to deal with the politics of it. Nixon, in each instance, all three. Andrew Johnson was not a Republican, he was a Democrat. So they were comfortable impeaching him. Nixon, the Congress was Democrat. Clinton, the Congress was Republican. All three were of opposite parties from the president. So you have to have that formula in which to even get into the ball game. But is it obsolete? Maybe, yeah. Yeah, Lou.
There's a lot of smart people out there. And why did they proceed with the process when you're indicating that it's futile?
Yeah, well, even me, I changed. It became so overwhelming in terms of consideration. I'm not necessarily making a judgment about the ultimate determination, but it was such that there should be an inquiry, and it just became so much that here you are, you have a president who says to an ally, we have almost $400 million of aid to you. Now, please, what you got to do to get that, you got to start an investigation against my leading opponent for public office, and you got to declare that. Now, to me, that sounds pretty irregular. So, yeah. So it became so overwhelming. As I said, Nancy Pelosi, the last thing she wanted was an impeachment. She knows the result is going to be very likely an acquittal. And she knows it's going to occupy the Congress and the Supreme Court, because there's the Chief Justice goes off into bodies. When there are other issues that she feels are more important in terms of even a political direction than an impeachment. But she just felt, it overwhelmed her after a while. So it became out of free choice, it became almost an absolute. Yeah, Michael.
As a result of this process, whatever happens, how do you think this will impact the future process of impeachment? Will it in some way change that process?
Well, it will always be, look, they made it enormously burdensome, and they knew what they were doing. They were saying it's not the whim of 2/3 of the United States Senate that decides who displaces the president that the American people have selected. So that kind of caution is welcome, and I think that kind of caution will continue. And the prospects of impeaching a president are very remote. Back to when George Mason said maladministration, and James Madison said, wait a minute, you're not going to talk about a guy who just doesn't know how to administer and get rid of him. There is a process, and the process is called an election. I think impeachment is in the Constitution. It's got 6 provisions, and the prospects of it likely happening are very remote, now and hereafter.
Some have argued that if Fox News had been around in 1972, Nixon never would have had to have resigned.
I was wondering if you could respond to that.
Well, I was around in 1972, but I wasn't watching Fox then, and I'm not watching it now, so I'm disqualified from doing it. But there's no question that, yeah, Fox has more of an impact than MSNBC and CNN combined in terms of viewing audience, so it would have done it. I don't know how it got to the point that was so overwhelming. Can you imagine the House voting 410 to 4 to have an inquiry? And now, when Clinton was impeached, 31 Democrats went with the Republicans. So there was some movement. But look at today. Almost 100% Democrats for inquiry, just inquiry. 100% of Republicans opposed. That forecasts to me what the outcome is going to be. If you're not voting for an inquiry, it's very unlikely you're going to vote for an actual impeachment. But Fox would have had an impact. Its audience would have heeded it and paid attention to it. Yeah. Thank you. Okay.
Thank you.
Okay.
Thank you all for coming and listening, and come next time.
When is next time?
I forget, the 25th or something. They'll know. They have their, I forget where it is.